May it please the Court, Lee Berlick again for Eric Hotung. Essentially what we're dealing with is this. We have a Hong Kong businessman who sued his father for defamation for denying being his father in an interview that he gave in Chinese in Hong Kong. Now, as you can see, Michael was very determined to sue his father. I mean, we just talked about the detrimental reliance claim, which was based on Eric's comment admitting paternity. Now we're dealing with a defamation claim, which is based on Eric's denying paternity. So Eric was going to get sued either way. For reasons known only to Michael, he brought this claim not in Hong Kong, where both parties lived, but here in Virginia. The key issues, I believe, are first, whether the Commonwealth of Virginia has any interest in adjudicating this dispute between two residents of Hong Kong over a cause of action that has no practical nexus whatsoever with the Commonwealth of Virginia. And the second issue is, if Virginia is going to adjudicate this dispute, are the allegations of the complaint sufficient to state a cause of action for defamation? And while there's 4 assignments of error in the briefs, I'm sure I'm not going to have time to address all of them. I'll do my best to answer any questions with respect to any of them, but I intend to focus on assignments 1 and 2. First is the forum nonconvenience issue. It's the first issue I want to address. And the one question that, if you have for me, I'm not going to be able to answer is, why was this action brought in Virginia? The trial judge asked, the only response was, well, Eric owns a house in Virginia. The house has nothing to do with the case, but that was the only reason given. The interview was in Hong Kong. All witnesses to the interview were in Hong Kong. The reporter was in Hong Kong. The publication that the reporter worked for was based in Hong Kong. So all witnesses, the events on which the complaint is based, and all witnesses to it, are all in Hong Kong. Nobody's in Virginia. Nobody's in D.C. As a defamation case, the plaintiff has to prove falsity. So the truth of what Eric said, he didn't just say, he's not my son. He said he's goofing around, he doesn't treat his wife and family well, and things like that. Those allegations survived demur. The truth of all of that is also at issue. So witnesses who would be able to testify as to whether or not what Eric said was true would also be in Hong Kong, because that's where Michael Hotung lives. The effect on Michael's reputation, if any, also would have been in Hong Kong, where Michael lives and where Michael is known. He's apparently a celebrity over there. He's not over here. You also have the community. Michael has conceded in his brief that the intended audience for this interview was the Chinese community, also in Hong Kong. So why are we here? You'll have to ask Michael that. But we have a statute that's designed specifically for this situation. It's 8.01-265, the forum nonconvenience statute. The first thing I did when I took this case was to present that motion for a hearing. It applies when you have a cause of action that arises outside of Virginia, when you have a plaintiff who's not a resident of Virginia, and when you have another forum that would be more convenient and that has jurisdiction over the party. If you have that, then if there's good cause for dismissal, the court should dismiss it. There's no dispute about any of these 3 prerequisites. The only issue argued below is whether there was good cause. The statute defines good cause, or provides an example of something that's good cause. It specifically says the avoidance of substantial inconvenience to the parties or the witnesses is good cause for dismissal. As I've mentioned, everybody was in Hong Kong. Not only the known witnesses, but the potential witnesses. I basically described all the pool of potential witnesses, but there were also 14 individuals that Eric identified to the trial court. These were his answers to interrogatories, the standard interrogatory asking about people who might know something relevant to the case. He identified 14 people, including himself and Michael, and with their contact information, all in Hong Kong. So those were the known witnesses. There's the potential pool of witnesses, including Michael's. But we also have the fact that Michael himself is Eric is 87 years old. He's in frail health. He has a brain injury. He gave the trial court 2 letters from doctors that mentioned this and that both advised him not to travel. So we have the good cause as defined in the statute. There's other things. There's the fact that it's a defamation case. In defamation cases, you look to, it depends on subtleties in meaning. You want to know exactly what was said, how it was said, how the community to which the statements were targeted would have interpreted those statements and whether they would have taken them literally, whether it would have tended to affect reputation in that community. Again, that's Hong Kong. So here we're asking a Fairfax County jury to decide, well, how would the reasonable Chinese person in Hong Kong hearing these statements in Chinese interpret it, literally or not? And what effect would that have on people in Hong Kong? So again, these are more reasons that this case should have been heard in Hong Kong. Trial judge denied the motion. He said good cause had not been shown. He wanted to hear evidence. And I don't think that's a reasonable thing to ask for. First, in the Norfolk Williams versus Williams, that case is directly on point and dealt with a situation where the plaintiff sued in Portsmouth when everything happened in Roanoke. And this court held it was an abuse of discretion to deny a motion to transfer that case based primarily on the inconvenience to witnesses and parties, but mostly witnesses. And there we're talking about a 4.5-hour drive. Here we're talking about the other side of the world. And not only that, but in Williams, there was no evidentiary hearing. And it was enough simply because, again, it's not, you don't have to tell the trial court the exact witnesses who are going to show up and testify. Just present the facts, and it's common sense when all the facts happened in Hong Kong, that's where the witnesses are going to be. And it's not reasonable to have to require them to travel across the world for the sake of the hearing on the transfer motion, or the dismissal motion, to testify that, yes, I know about this case and it's inconvenient for me to travel here. Now, I'd like to address the first assignment of error, which is this defamation claim. If Virginia is going to adjudicate the dispute, the question becomes, well, are the words alleged in the complaint defamatory? Should the jury have even considered this claim? And it clearly should not have. In life, sometimes people say things that aren't very nice, and society the law expects that you have to be able to absorb the occasional disparaging remark. Not everything is going to be defamatory. It has to be something that tends to affect reputation. And here in Virginia, the test seems to be defamatory in nature. The statement has to be one that is calculated to make the plaintiff appear odious, infamous, or ridiculous. I actually think this case presents a good opportunity to perhaps update that definition. That's from 1904, Moss versus Harwood. I'm not sure it's a fully accurate statement of the law today, because just about anything can make the plaintiff look ridiculous, and that doesn't necessarily mean it's defamatory. Virginia model jury instructions are based on Fourth Circuit law, which in turn are based on the Restatement of Torts. They talk about, to be defamatory, the statement must tend to harm a person's reputation so as to lower him in the estimation of the community or deter third persons from associating or dealing with him. We don't have that here. We have a statement that says, and the entire statement is on page 11 of my brief. It's fairly lengthy, but he essentially says, he's not my son. He does not conduct himself as a proper Hotung. Looking at his habits, he does not deserve to be related to me. Nobody in my family acts like this. And most tellingly, I am a gentleman, so I do not acknowledge him as a son. Now, we have two issues here. One is, well, how are these words to be interpreted? Sometimes people use the meaning of words does not correspond with literally what the words say. Sometimes people mean something slightly different. But assuming that you can interpret these words literally, the statement boils down to, I'm not his father. Michael is not my son. So the question is, if that's the statement, is that the type of statement that when people in the community hear, that they will be repulsed by you, they will want to have nothing to do with you, no dealings, it's going to bring you down in reputation and public esteem. And it's not. I mean, maybe in Hong Kong, but we didn't deal with Hong Kong law in this case. We dealt with Virginia law. Moss versus Harwood again said you don't look to the plaintiff and his special circumstances. You look to the community as a whole, and whether it would tend to affect reputation in the, quote, common estimation of mankind. But I don't think we even get there. because this is not a statement that can reasonably be interpreted literally. And that's a question of law for the trial judge to decide before even giving it to the jury. It's a trial judge's job to say, is this the type of thing that when people read, a reasonable interpretation would be that these two are not related by blood. And when you have statements such as, I am a gentleman, so I do not acknowledge him as a son, that tells you right there that he's not really saying, we're not related, this person's an imposter. He's saying he doesn't deserve it. I do not acknowledge him as a son. That's different than he is not my son. And Michael likes to emphasize that, he said DNA. He, quote, invoked DNA. DNA means that's the most scientifically verifiable proof of biological relationship. Since he invoked DNA, he must have been really serious that these two aren't related. And that's not correct, because what he said is that I did not take a DNA test. He could be the president's son for all you know. That's the statement. When you say I did not take a DNA test, that's saying I don't have this scientific proof of relationship. That was a true statement, and again, the fact that he said that shows that he is the putative son, and he's just saying, look, everyone tells me we're related. He also says in the statement, I've supported him. He says inconsistent things too. Like first he says, who is this guy? I don't know him. And in the very next breath, well, I supported him because I took pity on him. Everyone says he's my son, but I never took a DNA test. He could be the president's son. These internal inconsistencies are one indication that, well, he's not really intending to be taken seriously. And again, the court should be considering the context. But also, it's the words used is another part of the context. It's also where these publications appeared. On page 596 of the appendix, you see a cover of one of these publications. They're tabloids. It's like a cartoon. You have a picture of Michael Hotung with a little voice balloon. And in the voice balloon it says hypothetical dialogue. So you know right off the bat when you're reading this that you're reading, that it's talking about things that people may or may not have said. That's all part of the context that reasonable people would consider. With the court's permission, I'd like to reserve the rest of my time.
All right, thank you.
Thank you.
Good morning again. Tim Highland and Elizabeth Dwyer for Michael Hotung. Again, the trial court did not err in entering judgment on the defamation claim here, and actually in a reduced form. The court, I don't know if the court is terribly aware of this, but there was actually the verdict was twice what it is. The court reduced it by striking a insulting words claim, in which the jury had given another $600,000 verdict. So we're really already at half, and we have not appealed that rule. As to the forum nonconvenience claim, again, this court looks at that from an abuse of discretion perspective. And I just want to tell you why I think that's easily resolved without even getting into the fact that they refused to put on any evidence to support their suggestion that all of this happened outside of the United States and that these witnesses were outside of the United States. But firstly, Eric conceded the point. And you'll find it at Appendix 168. He wrote a letter to the court. I don't recall the exact date of the letter, but it was filed with the court on the 14th of March, 2012. And in that, he said, and I quote, "My wish to waive this side issue of personal jurisdiction and get to the heart of the claim." I'm not sure what else he was indicating to the court other than he wanted to get to the heart of the claim, and by golly, we got to the heart of the claim. But this was, he had discarded this until he then got his fourth counsel, and then it got brought up, which takes us to the other easy resolution, and that is this court's decision in Faison versus Hudson. And in that case, the court affirmed a trial court's refusal of a motion, in that case, to transfer venue when it was brought before the court 6 months after filing, just because it took, what's the delay? Here, Eric delayed 9 months, not just 6, as it relies on.
But wasn't part of that because the court felt like the personal jurisdiction issue was a threshold matter that needed to be resolved before you got to anything else?
I would suggest a relatively small chunk of that was.
And then there was a hearing that got postponed.
Well, the hearing, can I tell you why the hearing got postponed? And this is why it's a little bit off-putting, to be kind, that they would say, well, it got pushed off because of this. The original hearing, I'll never forget, it was scheduled for Valentine's Day, February 14th. And right around weeks before that, we had scuffled. The court had said, you can go do a jurisdiction.
Is this all on the record?
It is.
All right.
There was a deposition to be taken of Mr. Hotung. They said, you got to go to him. We scuffled over where it was to be, and it was scheduled for, I want to say, either the very end of January or the first of February. I want to say it was the first week of February, right before this February 14th hearing on jurisdiction. And Mr. Hotung, on the eve of the deposition over there, had his own company sue him, no kidding, in a collusive suit, and got an injunction against him answering any of the questions that were pertinent in the deposition. And so we got to the deposition, and he, for the most part, refused to answer anything, saying, well, I'll be in contempt of court under the injunction that I just got against myself. Ultimately, he was sanctioned for that by the trial court, $55,000 for that stunt. I'm sorry.
Doesn't that, in fact, argue in favor of their forum's nonconvenience argument? That if he's doing those sorts of shenanigans over in his home country, that it would be a court of his home country that could truly have a meaningful sanction in terms of making him come to the deposition?
Well, the court in this case had that jurisdiction because he lived here. That's the great irony of all.
No, I'm not making a jurisdictional.
Okay.
It's not a jurisdictional question. It's a forum nonconvenience question.
But
if he's asking a Hong Kong court to do that, and if this case was in a Hong Kong court, it would get resolved real quickly.
Well, it would get resolved real quickly.
Probably be sanctions that didn't involve money.
Except I don't mean to impugn the Hong Kong system, but Mr. Hotung has an outsized level of influence and ability to maneuver the system in Hong Kong. And for that reason, it's not really a jurisdiction that is terribly favorable to anyone who might wish to cross paths with Mr. Hotung. But be as it may, there was this delay. But my point, I'm sorry, Chief Justice Kinzer, but the delay, bottom line, was caused by Mr. Hotung and no one else. He can argue that up to February 14th the delay was his, but then he was ordered to appear for a deposition here. He didn't show up. Instead, he wrote this letter saying, "Get it, I can see." And that's the letter, again, that you'll find it at Appendix 168. I'm sorry, Justice.
Yeah, I'm sorry. Is your question answered? I'd like to actually get to, when we do a forum nonconvenience analysis, we're going to look not only at case by case, but we have to look at exactly what it is that's being pled. And there are some wrongs that are pled where it's apparent they either happened or they didn't happen. Defamation is, in a way, almost like alchemy. You've got to look. Fact versus opinion is one of the key elements. But if you look at our fact versus opinion cases over the past 5 years or so, it's even a finer line. Was it hyperbole or not? Was it by implication or not? I was going to use the term nuance. Your opposing counsel used the term subtlety. The subtleties, the nuances are often cultural. It's not only from country to, sometimes from locality to locality, but certainly from country to country. If you make a joke with me and I say, "Counsel, you're killing me," everyone understands what that is here. It might be viewed as a threat somewhere else.
Sure.
How can a Virginia court possibly, or a Virginia jury possibly, understand the implications, the nuances, the subtleties, the hyperbole, potentially, of statements made in another language in another country?
There are three answers for that. The first one is that's frankly not part of the analysis here, because the analysis is convenience to the witnesses and the parties. But assume that it is, because I think it's a fair question in its own right. Number one...
At least one party would say it's... Anyway, go ahead.
From a convenience perspective, I'm being somewhat narrow in my reading. But from a more practical perspective, the other two answers are, number one, sure they can be, and indeed, in this case, the jury got that information. There was an expert witness, and her testimony's here in the record. Her name's Janet Tan, T-A-N. And Janet Tan testified as to how a person who's reading Cantonese or standardized Chinese, depending on what portion of these papers is written, might perceive these statements. And indeed, she said that they would be perceived quite literally and as factual because of nuances in the language and what have you. Indeed, that's, interestingly, is a textbook example of this Court's wisdom in its reticence from time to time to let cases go on demur where there are these sorts of subtleties and things. Because while you might look at these statements and say, well, that statement just looks kind of like an opinion to me, just using it as an example. Indeed, in this case, when she got the testimony in, it showed that, no, not really. And that's to speakers that are located physically in Indochina area. The third answer, Justice Mims, is as follows. That is, bear in mind also these statements, and this was the testimony of Mr. Kelkar trial, were published in the United States, not just in the United States, but in Fairfax County. And so again, all of this Hong Kong focus isn't really entirely accurate. These statements were published in Fairfax County, and that's where this jury is from. Now, do we want to then limit it down? How micro do we need to be? Do we need to get into the Chinese-speaking community in Northern Virginia? I don't know how micro we get. I don't know if you can break it down quite that far. But at core, in this case, the jury did get that. And maybe that's the difference from the generalized sort of case. But here, the jury did hear what these statements meant in that culture, and what their import was, and what their subtlety, their context in that culture. So, in this instance, it was shown how those affected your normal hearer, both in Hong Kong and here in Virginia. So there's that. I also want to point out that the 14 witnesses that counsel mentioned were, number one, they weren't identified until the very eve of the hearing on the motion, and each of them, but for the two Mr. Hotungs, the parties, was to testify as to things like prior bad acts, was to testify as to whether Eric, in fact, made the statements, what have you. It was those sorts of things. Not a single one of those items that they identified as being the subject matter of what we're going to be testified was admissible in evidence, except the concept of whether Mr. Hotung made a statement or did not make a statement. However, the trial court solved that problem for us because the trial court refused to allow us on hearsay grounds to put into evidence any statement that was not admitted to have being made by Mr. Hotung. So the only things the jury heard were statements that Mr. Hotung admitted to have made. So these witnesses from Hong Kong, whoever they might be, couldn't rebut anything because there wasn't any issue as to what Mr. Hotung did or did not say. They rely heavily, by the way, on this Norfolk and Western case. I'll just point out that Norfolk and Western had nobody located in Portsmouth. Nobody, nothing. Portsmouth was just picked out of the air. probably for choice of jury and what have you. But Portsmouth had no connection whatsoever with the case. Here, we have a gentleman who lived in Fairfax County, and this goes back to Justice Mims' question in the prior appeal about transitory matters sort of following the person around. And you can be sued where you sit. And Mr. Hotung sat right in Fairfax County. He lived in a house that he purchased from Ted Kennedy, and it sits, for those of you who know it, right up on Chainbridge Road in McLean.
Counsel, you've only got 2 minutes left. I want to move actually to the merits, the substance of the assignment of error relating to whether the demurrer should have been sustained. And I have to smile. You would certainly know the Highland case, I would think.
I have no relation, but sure. I'm familiar with the Highland case.
If any of the statements that went to the jury were opinion, then it is error. And I want to just read 3 statements out of your complaint. I'm looking at page 9, paragraphs 53 and 54. Judging by his habits, he can't possibly be a relative of mine. He has a bad business ethic. I am a gentleman, so I do not acknowledge him as my son. How are those denials of the fact of biological paternity?
Standing alone, without any of the surrounding statements and everything like that, those statements might escape being statements of fact. Incidentally, this isn't about parentage. This is about painting a picture of someone by implication that he is a fraud, a phony, a pretender to the crown, as it were. This is sort of the Anastasia type thing, where you're saying she's not the real Romanoff, when in fact she is.
But I thought you just said it's not about parentage. It is about parentage.
Well, it's about Eric's denial of parentage, which is used in a fashion to be defamatory. Again, remember, defamatory statements, and this is where Highland, I would suggest, is correct on its facts, and it deals with things as it's placed before it, because it has these snippets of statements. And the 3 that just mentioned are certainly by themselves, again, worrisome a little bit.
Counsel, if you're making the implication argument, an implication must be reasonable. The conclusion one reaches from the implication must be a reasonable conclusion. How could I look at a statement saying he has a bad business ethic and say, oh, that means that he's denying parentage and that in terms of your big picture, this is a nail in the coffin?
Well, put in the context of a string of statements where Eric has said, this guy is not one of us. Because we do it this way, we the Hotung. We do it this way. He's not one of us. He's not really my son. Therefore, all of this stuff he's been saying for the last 6 years. I see my time is doing it. Stop.
Answer the question. Yes.
Okay. For the last 6 years, he's been going around saying he's one of us. And for all of these various reasons, I can prove that he's not one of us. He's a fake. He's a pretender. You have to look at it, I would suggest, in bulk. You cannot take out little statements here and there. And there are cases out of this court that we have cited in our brief that would suggest that you need to look at all of this, and you don't have to parse out what the little opinion here and the little things that's laden with opinion but factual here. You just put it out there, and the jury is instructed to find, is it fact, or is it true, or is it false, or what? And they can't find it false if it's opinion. That's my question.
Thank you.
You've answered my question.
Thank you, Your Honor.
Thank you. To get back to the Highland case, that's directly on point. This court held in Highland, and there's 2 opinions. They're both relevant to this appeal. I'll call it Highland 1 in 2007. That's the opinion that held it's reversible error to instruct the jury on a statement of opinion. But the statements that you pointed out in the complaint, but there's also, I'm looking at the jury instruction on page 695 of the appendix, paragraph D. The problem is how the jury was instructed. The problem wasn't that the jury was made aware of these statements. The problem is that the jury is told, you shall return your verdict for the plaintiff, etc., if the defendant made any of the following statements. And then they're broken down into these arbitrarily paragraphed snippets, as I'll call it. One of them is, every man in the Hotung family is affectionate and righteous and never does such things as abandoning his wife and goofing around, not attending to his proper duty. It is impossible that this kind of people is a member of my family. That's another example of opinion, and the problem is that for all we know, since the jury was not told to explain on its verdict form which statement it found to be defamatory, we could have a $600,000 verdict based solely on that obvious statement of opinion. Counsel suggested that Eric Hotung waived his forum nonconvenience argument in a letter he wrote to the court. He did not do that. That letter is on page 115 of the appendix. It's in the very first paragraph, he says he concedes the issue of personal jurisdiction. He didn't have a lawyer, obviously, when he wrote that, but he was very clear in what he wanted. Later, he says in the same letter, Michael's case is bound to fail due to forum nonconvenience, meaning the case should not be tried in the USA but in Hong Kong. He even says later that he's angry with his previous lawyer at this point. He says, I told my lawyer to do one thing and to move on to forum nonconvenience. Again in the letter, if Michael so wishes, he can bring his case in Hong Kong where I reside. So it's clear he did not waive any argument. Next, the suggestion has been made that there was expert testimony. May I go a little bit beyond my time?
To continue.
The expert testimony of Janet Tan. Janet Tan was not introduced, or she was not admitted as an expert in how the community of Hong Kong would have interpreted these Chinese statements. That's on page 485 of the appendix. The judge said she's a translator. The only reason she was in court is to translate these Chinese statements. Moreover, she did not testify as to what she thought the Chinese community would have thought of these statements. She spoke from her own personal opinion. She said that she thought the statements were harsh in a bad situation, which really just shows that she interpreted them non-literally, as a rift between father and son. That's why it's a bad situation. It's sad, and the father is disavowing his son. This argument was also made that these statements were published in the United States or in Virginia. That's a misnomer because we're talking about two different kinds of publication. In the defamation case, the publication we're talking about is not the printing of a magazine and the fact that these tabloids are available online anywhere in the world. We're talking about the communication of a statement alleged to be defamatory to a third party. That's what publication means for choice of law purposes in the defamation context.
Okay, thank you. You've had about a minute more. Thank you. The court will take a short recess.
All rise.